Welcome back, this is Francisco Rosa. Today I'm going to go over a standard purchase and sale agreement. To start, first of all, you start off with the date. Then we have the names of the sellers and then the name of the buyers. The following clause shows the property address. Here we have 321 Main Street, Malden, Massachusetts. It also should have the identification information for where the deed was recorded. Paragraph 3 shows you what you're getting with the property, and this is what we call real estate. So you get everything attached to the property. People make a mistake believing that all the furniture and appliances might be included. That isn't necessarily the case. So if you want to make sure that you're getting the refrigerator, the stove, anything else in particular that you think is important or part of the sale, make sure it's included in the offer or that it's included on the P&S when you sign it. Here we have the sale includes all kitchen appliances and lighting fixtures. Don't be surprised if you do the walkthrough and the refrigerator is gone. A refrigerator is not real estate, it's personal property, and therefore the only way to know that it's actually included is to make sure it's in the offer or it's included in this section, paragraph 3. Next, paragraph 4. Paragraph 4 indicates that the buyer will get free and clear title, good and clear and marketable title, only subject to encumbrances related to zoning, taxes, any liens for municipal betterments assessed after the date of the agreement. This can technically be edited, but for the most part, you will be subject to anything that the city charges subsequent to the purchase. The next section indicates that if for any reason plans are still needed for the property, the seller will provide them prior to closing. Because some properties are registered land, they must comply with the necessary requirements so that they can register title. Most are not, but if it were necessary, the seller has to promise to pay that. Paragraph 7 is very important because it details the purchase price. First of all, you have the full purchase price. Next, you have what is the deposit that the buyer has paid with the offer. Immediately after, you see what the deposit is that is being provided at the time the purchase and sale is signed, and then what is the balance at the time of closing. The balance at the time of closing is a combination of the loan and the balance of the down payment. If this was a cash offer or a cash buyer, obviously they wouldn't have a loan and they'd be paying the whole thing at closing. Paragraph 8 indicates time for performance. When is the closing date? If you're financing your transaction, chances are you need to give yourself at least 30 to 45 days. That's usually the standard. Now, if you're working with somebody and they've promised that they can do the deal faster, great. If you're working with a seller that needs more time before they leave, well, then you have the opposite. Then you'll have a prolonged closing. But nonetheless, the date is negotiable between both parties, and in failing to do so, you would have breached the agreement. So make sure that you understand that. Paragraph 9 indicates that you are likely to get the property free and clear of all tenants and their possessions, meaning empty without anybody there. If you're buying a multi-unit property, this paragraph would include which unit is being delivered empty and which units are being delivered occupied. So if it's a two-family and you're moving into one, you'd have to make sure that one unit is empty and then the other one would be subject to the current tenants. If you're buying an investment property, instead of free and clear of all tenants, it would just say subject to the current tenants. Next, paragraph 10 simply indicates that if the seller for any reason is unable to deliver the title to the property free and clear, he has the right to extend up to 30 days to clear up. You must agree to the extension, but they are entitled to get an opportunity to clear the title. Paragraph 11 indicates that if they fail to clear up title, you still have the option of taking title to the property if you wish. I would be cautious of this because you should only accept title to things that you will be able to clear up on your own, or that will clear up with time. If it's significant, then the best step to take would be to just grant further extension, or in the worst case scenario where it cannot be done, walk away, cancel the transaction. Paragraph 12. If you decide to accept title in the current condition that it is, you will get it subject to the conditions already in place. In addition, it advises that you have multiple choices over what happens if the property is damaged by fire or other types of damage. A says, on the first hand, the seller can pay over to the buyer at the time of delivery of the deed any money is recovered on account of insurance, less any money that they've spent on partial restoration. Paragraph B says that if the mortgage holder is holding the money and they do not permit the money to be used to fix the property yet, they can take delivery of the deed and then be responsible for doing the work necessary to restore the property to its fixed condition. 14. At the time of the sale, the seller is entitled to use proceeds to clear title. In this case, we're referring to the ability to pay off any current mortgage or outstanding debt or liens on the property. What kind of things do we pay off on behalf of the seller? The mortgage, outstanding taxes, outstanding water, and then depending on your city or state, there might be other things for which you adjust. Paragraph 15 indicates insurance. The risk of loss remains with the seller until the deed is delivered and recorded. The buyer does not become owner until the deed is recorded. At the time of closing, according to paragraph 16, we will make adjustments for water, sewer, and real estate taxes. Again, if you're buying a multifamily unit or investment property, you would also include language that you will adjust rent on a per diem basis. You will also adjust for last month's deposits, any security deposits, and any interest that may be due to the tenants. 17. If for any reason the taxes are not yet known, the parties agree to cooperate in fixing the adjustments subsequent to the transactions. It's very rare that we have to deal with this clause, but it's there for that specific reason. Paragraph 18 indicates that if there are agents involved, it must list who they are, and paragraph 19 just expresses that the agents are licensed in the Commonwealth of Massachusetts. It's just giving assurances that they are licensed to do business in the state that the transaction is being conducted. Paragraph 20 indicates who will be holding the deposit. If a disagreement occurs, both parties agree that the only way that the deposit will be released is by mutual instructions signed by both parties. So if the transaction is canceled, both parties must agree in writing that one of them will get the deposit, whether it's the buyer, whether it's the seller, or they split it. Now, we rarely get into this situation, but you want to know who's holding it because that's who you want to deal with. Now, if the buyer defaults, under certain conditions of course, and fails to complete the purchase, assuming that they cannot back out and there isn't a clause that protects the deposit, then the seller is entitled to damages, which in effect is the deposit. If they're married and the title does not have their spouse on the deed, in Massachusetts we require the spouse to also sign the deed for purposes of releasing their right of homestead. The brokers join this agreement solely for the purpose of participating as agents. Paragraph 24 indicates that if the purchase and sale agreement is signed as a trustee, shareholder, or beneficiary, then the person does not face any personal liability. So if you hold title to the property in an LLC or a trust or an estate, the signatory is not personally liable for any obligation in the contract. Paragraph 25, warranties and representations, simply states none. Here's where you would want to put whether the seller has made any warranties to the buyer. In most standard transactions that we conduct, there are never any warranties given simply because That's just standard practice. But everything's negotiable, so feel free to ask. Paragraph 26 is very important because if you're purchasing a home and you're financing, it specifically states that as part of the purchase agreement, you will apply for a loan of a specific amount with the expectation that you will receive a loan commitment by a specific date, generally about a week or so prior to the actual closing date. If for any reason your loan commitment has not been issued, which means the bank has not yet promised to lend you the money, you will need to notify the seller because you have two choices. You can either terminate the agreement or you can seek an extension. We always seek an extension, but in the worst case scenario, you have the ability to terminate the contract and get a reimbursement of the full deposit, simply for the reason that the loan was not approved. So make sure that you do not miss the deadline, otherwise in failing to get the loan and in failing to notify the seller by not being able to complete the purchase on the specified date, you have breached the contract, and the default will be that the seller gets to keep that deposit as liquidated damages. Construction of this agreement. It just means this is a Massachusetts contract to be enforced in the state. Lead paint law. All buyers and sellers must sign a lead paint disclosure as part of the purchase and sale agreement process. Massachusetts requires that they get a disclosure, and it's a similar requirement for pretty much any state. So this is just an acknowledgement that that has occurred. Paragraph 29 simply states that the seller will deliver to the buyer a certificate from the fire department in which it states that the property is properly equipped with working carbon monoxide and smoke detectors in conformity with applicable law. Paragraph 30 is just the context of who might represent buyer and seller, or if they do not have representation, their personal contact information. Paragraph 31 is where you would add any additional conditions. For example, it is very common for a seller to seek a credit from the buyer, a closing cost credit. So normally it would read, for example, seller to provide buyer a $5,000 closing cost credit at the time of closing. Or if you have additional personal property that's included in the transaction, it might state seller shall leave television, sofa, refrigerator at no additional consideration to buyer. And then we have the most important part, the signatures, which make the contract binding. Again, when this contract is signed, the agents or escrow agent or closing attorney expects the buyer to provide the deposit as part of the transaction. It's the money that really binds the contract, because if you were to sign it with no money, then if it were to be enforced, there's zero in hand to enforce it for liquidated damages. I mean, apart from the $1,000, that really isn't much.